first Arbitration Act was enforced in 1899. It has been more than 120 years, and India is still viewed as an archaic system of arbitration rules. However, the judgments and amendment in the Principal Act of 1996 have clearly expressed the lawmakers' intention to progress India as an arbitration-friendly regime. After 1966 Act, this act has been amended in 2015, then in 2019, and very recently in 2021. To gain a deep understanding of arbitration and its related amendments, leaving its impact on India, today we have an arbitrator himself, Mr. J.N.Yadav. Sir has joined Himachal Judiciary as a civil judge in 1987 and was elevated to higher judiciary in 2006. He was retired in 2014 as a district judge. Since then, Sir is under the panel of Delhi High Court, serving as an arbitrator. Welcome, sir, to the LegalStix. Welcome.
Thank you, and good afternoon to all of you. We have been discussing today about the arbitration. So you will put questions, so let me explain what is the arbitration.
Yes, sir.
Before putting,
I was about to begin with that. What is the Arbitration and Conciliation Act, and what is its purpose?
let me first explain what is arbitration. Arbitration is a process of resolution of disputes, commercial disputes mainly, outside the court. Act 1996 has been enacted and it came into force in August 1996. You have rightly stated that it has been amended several times. It was drastically amended in the year 2015 and it came into force on 23rd of October 2015. Thereafter, it had been amended in 2019 and recently it has been amended in 2021. Arbitration, the object of this Arbitration Act is to provide cheap and speedy justice to the parties without going to the courts. The parties choose their own arbitrator. They give the name of the arbitrator. Now it has recently been held by the Supreme Court in Perkins case that unilateral appointment is bad in law. Arbitrator is to be appointed with the consent of both the parties. Previously, what was the position? That in the agreements executed between the parties, generally a clause is inserted that the right to appoint the arbitrator lies with party A or party B. Now, with the recent decision of the Supreme Court in Perkins case, it has been specifically stated that unilateral appointment of arbitrator is bad in law and unilateral appointment does not, the clause which gives right to the parties for unilateral appointment is not a valid clause. Now, if the parties don't agree regarding appointment of the arbitrator of a particular person, suppose A says that I want to appoint A as an arbitrator and B is not agreeable to it, other party is not willing to appoint particular person as arbitrator, then the remedy lies with the parties to go to the Honorable High Court under Section 11 of the Arbitration Act and to get the arbitrator appointed from the court. Then.
Okay, very well said, sir. So, what are the advantages of arbitration over litigation in India?
What are the advantages?
Yes, over litigation.
Advantages are that timely justice is provided to the parties. This is the one of the advantage, and this is the object for which this act has been enacted. I may tell you here that if the party go to the court for the decision of his rights, the procedure is so long that a party during his lifetime may not be able to get justice from the court. He may not be able to know whether the stand which he has taken or whether the right which he is claiming he is right or wrong. Even his next generation may not be able to know whether his father, who has initiated proceedings in the civil court, whether he has any right or not. Only third generation will be able to know ki the right which my grandfather has claimed, whether he is right or not. So this is the such lengthy procedure. In order to avoid these lengthy procedure, this Arbitration Act has been enacted, and it is very effective in the disposal of commercial disputes. And particularly, this act provides that the arbitrator has to decide the dispute as per terms of the agreement which has been executed between the parties. Arbitrator is not bound to follow the procedure of CPC and Evidence Act. These Evidence Act and CPC are not strictly applicable. Arbitrator can adopt his own procedure. That is the that is why the parties are coming to the arbitrator
Yeah,
for
I
the
think the arbitrator has so many discretionary power.
no much discretionary power.
Okay,
Arbitrator is bound by the terms of the agreement.
okay.
Even the Supreme Court has held in so many cases that arbitrator cannot question that this term is not right and this term is not, why this term has been introduced by the parties in the contract. Arbitrator, if the language of the contract is plain and there is no ambiguity in it, then the arbitrator has to decide the dispute as per terms of the agreement which has been executed by the parties, and the arbitrator cannot impose upon its own opinion that this
Yes.
term should have been like this or this term should have been like this.
Correct. So I have a doubt here that see, you have just said and rightly pointed that the main purpose behind arbitration is speedy disposal of the dispute.
Provide
Yes.
speedy
So once
disposal of
the yes,
dispute.
so once the arbitrator passes this award, then
Mm,
for the execution,
mm,
when the party has to go to the district court for the execution petition, then
mm,
I think the new war starts from there, which is again, I think then again the delay procedure follows.
No, let me tell you one thing here, that earlier there was no time limit for the disposal of the dispute. After the enactment of amendment of 2015, time limit has been fixed in the act itself, that arbitrator has to complete the proceedings within 1 year from the date of completion of the proceedings. And the time limit has also been fixed for the completion of the pleadings, that is 6 months. That is maximum 1 year and 6 months can be consumed by the arbitrator to decide the disputes if the and arbitrator in the beginning has to disclose that he is an independent and impartial and has no interest either in the subject matter or in any of the parties, and is having ability to complete the arbitration proceedings within the period stipulated by the statute. If the arbitrator has failed to complete the arbitration proceedings within the period prescribed by the statute, then the mandate of the arbitrator
Hmm.
stands terminated, and it is only the court which can extend the mandate of the arbitrator. And the court under section 29A, the court can extend maximum for 6 months for the completion of the arbitration proceedings. That is why now your next question is that it is being delayed while executing the award.
Yes, sir.
Do you know that the court has to execute the award as it is a decree of the court? The court, as per CPC, the court has to execute the decree as it is. Court has no power to interfere that this is incorrect, this it is not in. Court has to, the simple words are that court has to execute the award as it is. He has no right to question it is legal or illegal, or it is enforceable or not enforceable. He has to execute as it is. So far as the challenge of the arbitration award is concerned, Section 34 of the Arbitration Act provides how the award can be challenged and what are the grounds for challenging the award. So there are very few grounds for challenging the award. If it is against the public policy, or Section 28(3) also lays down that if the award has not been passed as per terms of the agreement, these are the very few grounds on which an award can be challenged. Even the court, less interference of the court, very less interference of the court in the matters regarding uh, opinion or grounds given by the arbitrator. If the reasoning given by the arbitrator is reasonable or in accordance with the terms of the agreement, that court has no power to say that no, another interpretation is more reasonable as given by the arbitrator. Whatever arbitrator has opined, if it is reasonable, then the court hardly interfere in the award passed by the arbitrator. What is your
Yes, sir.
next?
So, I would like to ask one more question related to the role of arbitrator in the arbitration proceeding in India.
Mhm.
Because you have mentioned that the role of arbitrator is just he has to actually abide by what the agreement states. So,
Mhm.
what exactly then is the role of an arbitrator?
The role of the arbitrator is that if the dispute has come to the arbitrator, then he will give opportunity to the parties to file statement of claim and statement of defense. Party will be asked the same procedure. Arbitrator has to adopt his own procedure. He
Hmm.
may adopt the procedure with the consent of the parties, whether oral evidence is to be taken, whether evidence by way of affidavit is to be taken, which procedure is to be followed, which language, place of arbitration. If it is not specifically mentioned in the agreement, then place of arbitration may be decided with the consent of the parties by the arbitrator. Arbitrator has to, in the same manner as he has been acting as the procedure is followed in the court, the same procedure is followed in here in the arbitration proceedings. Arbitrator asks the parties to file their statement of claim and statement of defense or counterclaim. If the statement of claim is filed, the copy of that statement of claim which be supplied to the other party to file the statement of defense or a counterclaim, and then rejoinder will opportunity will be given to the parties to file rejoinder, and parties will be directed to file admission and denial on affidavit, and thereafter issues will be framed and it will be decided whether oral evidence is required to be taken or only uh, documentary evidence is sufficient to decide the controversy in dispute.
Yes.
This is the procedure.
Yeah. So if we talk about arbitration, then there is arbitration which is referred by the parties themselves by
Mm.
adding an arbitration clause in their agreement.
Mm.
But if there is no such agreement, then how can arbitration be initiated? Is there any other way?
Yes, yes. Here I would like to say that section 89 of CPC 89 of CPC provides if the dispute is in the court, parties have gone to the court, and Section 89 CPC provides that if there is an element of settlement of dispute, then court may refer the matter to the arbitrator. Court may refer the dispute to the arbitrator by framing point to be decided by the arbitrator. This is the method of. Yes.
Okay. So I think we can also call it as statutory arbitration.
Yes, statutory arbitration, there are some statutes which provides that the matter will be referred to the arbitrator. That is Railway Act.
Hmm.
If the land has been acquired by the railway authorities, then Act itself provides that the parties will go to the arbitrator for enhancement of compensation. And that Act provides itself that who will be the arbitrator. Government itself appoint the arbitrator. In case of Haryana, I am telling you, the government railway has acquired land here in Gurgaon, uh, and the Haryana government has appointed commissioner here as an arbitrator who will decide whether this compensation is required to be enhanced or not. That matter will be decided by the arbitrator. In National Highway Authority of Act also provides that central government will decide appoint the arbitrator. So in such cases, these are the statutory arbitration. Yes.
Okay. Arbitration has become popular method for resolving disputes outside
Mm,
of the court system,
mm,
particularly in commercial matters.
mm.
Also, there are two types of arbitration methods available, and which are institutional arbitration and ad hoc arbitration. Can you please
Yes.
explain them?
Yes. Ad hoc arbitration is the arbitration which is appointed by the parties themselves. And institutional arbitrations are the arbitrations which are appointed by the institution which has been designated by the court, by the Supreme Court or the High Court. There are certain institutions which have been designated by the Supreme Court or the High Court, like FICCI, Indian Council of Arbitrations. It is an institution. This institution appoints the arbitrator. I am also member of the FICCI,
Yes.
and arbitrators are appointed there. But this institution arbitrations are uh, very costly. Parties do not prefer to go there. Very high stake disputes goes to the institutional arbitrations. Otherwise, the disputes which are of not high stakes, those are generally decided by the ad hoc arbitrations. It is the choice of the parties to appoint the arbitrator. It is the parties may also negotiate with the arbitrator regarding fixation of fees. Parties may also assist the arbitrator regarding fixing the procedure to be followed in the arbitration proceedings. So people prefer to go to the ad hoc arbitrations because it is appointed by the parties themselves and it is less costly as compared to the institutional arbitration. This is my opinion.
Okay.
Yes.
Uh, but I think that Singapore and UK, the
Mm,
arbitration system in both the countries, they are the best as of now. So, and I think the reason being of their best is because the institutional arbitration is so properly established in there in terms of institutions, in terms of the laws regarding the appointment of arbitration, everything is well defined. And
mm.
could that be one of the reason that India is still way behind um, in like where the parties, international parties, can choose India as a platform for resolution of disputes, especially
Mm,
commercial disputes?
mm.
Is it the reason? Because you
The
just said
region,
stated.
the,
So
the, the region which I think is, there may be so many regions, but one of the regions which, in my opinion, is that their local laws in Singapore and in UK, their local laws supports the arbitration. In India, there are certain loopholes which are not giving much support. No doubt, amendments have been made in the Arbitration Act itself, and the object of the amendment is to make India a hub of international arbitration or to give boost to international arbitration in India or to increase the ranking of the India in the ease of doing business.
Yes.
These are the amendments, but still our laws are not as sportive as the laws in Singapore and UK are sportive to the arbitration. That is why prefer, people prefer to go to the international arbitrations in Singapore and UK. The all international arbitrations are conducted mostly in Singapore and in UK as
Yes.
compared to India. That is.
Yes. So I would want you to again clear that how are arbitrators appointed in institutional arbitration as well as ad hoc arbitration? Is there a difference between the appointment of the arbitration in both of these?
Hmm. It depends upon the clause contained in the agreement itself. If the arbitration clause contains that in the case the dispute arises between the parties will go to the FICCI or that particular institution, and arbitrator will be appointed by that institution. If the parties, if the clause in the agreement says that is case of dispute, the parties themselves will appoint the arbitrator.
Hmm.
Sometimes it depends upon the clause of the agreement. Sometimes arbitration clause says that one party will appoint one arbitrator, other party will appoint another arbitrator, and they will appoint third
Third
arbitrator. That is
arbitrator.
arbitrator. Arbitrators are always appointed in an even number, like 3, 5, 7. Not there cannot be two arbitrators. Those will be in 3, 5, 7, 9. So sometimes, if suppose I am giving you an example that an agreement contains an arbitration clause that in case of dispute, party A will appoint its own arbitrator and party will B will appoint its own arbitrator, and they will appoint the third arbitrator, presiding arbitrator.
Hmm.
Arbitrator appointed by one party is called nominee arbitrator of that party, and third arbitrator appointed by both the arbitrators is called presiding arbitrator. Suppose both the arbitrators of the parties, nominee arbitrators of the parties,
Hmm.
have failed to appoint the third arbitrator, presiding arbitrator,
Hmm.
then the remedy is that the party which has initiated the arbitration proceedings will go to the High Court under Section 11 of the Arbitration Act, and then
Hmm.
Honorable High Court or the Supreme Court will appoint the presiding arbitrator. Ji.
Okay. As per the surveys and all the data that are available, we have found that in India, ad hoc
Hmm.
arbitration is more prevalent than institutional arbitration. Why is
Hmm.
it?
Ad hoc arbitration is cheaper as compared to institutional arbitration. Ad hoc arbitration is the procedure where the parties choose their own arbitrator. The arbitrator is appointed at the according to the choice of the parties. In institutional arbitration, arbitrator is appointed by the institution.
Hmm.
That is why people prefer to go to, and this arbitration by the ad hoc arbitration, it disputes are resolved within shorter period. Much less time is consumed in ad hoc arbitrations while deciding the dispute, while long time is consumed in institutional arbitrations while deciding the dispute.
Yes. So, like you mentioned, that there are certain loopholes that
Hmm,
has resulted in
hmm,
where the international parties do not opt India as a preferable option for commercial arbitration dispute.
hmm,
And that's the reason United Kingdom and Singapore is the most preferable by the parties.
hmm.
What do you think that India should work on the implementation of laws related to the arbitration? What
It's
should India do?
it's informative. It's to make it more effective. To my mind, its execution should be more effective.
So what do you
Executing
mean
law
by more effective laws?
in the year 2019, this amendment was made in the act that uh, stay will not be award will not be stayed. Enforcement of the award will not be stayed by the uh, suppose one party had challenged the award under section 34. Filing of challenging of the award will not stay the execution of the award automatically. Only will stay the enforcement of the award or execution of the award if he is satisfied that there are reasonable grounds for staying the operation of the award or staying the execution of the award. Prior to the amendment, if the award is challenged under section 34, execution is automatically stayed. Then this amendment was made that execution will not be stayed unless an application is made by the party and the court, after having satisfied that there are reasonable grounds for staying the execution of the award, only then it will be stayed. Now the amendment has again been made. I think it is section 36(3).
36 plus 3, yes.
36(3),
Where they are providing
where
stay,
it has been
unconditional
provided
stay.
that if the court is of opinion that the award has been obtained by affecting word fraud or corruption has
Hmm.
been used in this section itself, then court may grant the stay.
Hmm.
So that is why if its execution is made easier, then people will prefer to go for arbitration.
Yeah.
If its execution is not, it is easy to get the award, but it is very difficult to get it executed. The
Hmm.
real difficulty starts when the award is to be executed.
Executed. Correct.
This is the real difficulty starts. Sometimes a person had obtained an award of 5 crores, 10 crores against B. If he will file the execution of the award, court will ask file the list of the property
Yes.
of the
Yes.
respondent, give his bank address, give the details of his. If he is not found, then it becomes very difficult. It takes long time to execute the award.
And I think
That
that's
is
the
why.
reason party preferred that's better to go to the court only directly. Then
Yes,
it
yes,
is at the same time.
that is why. Yeah, that is why.
Yes,
That,
exactly. So you have been an arbitrator yourself since 2014. So
mm.
what loopholes do you see in the legislations of arbitration or any other?
What I have not followed the question.
Yeah,
Would you like to
I'm
repeat
saying,
the question
yeah,
again? Mm,
sure. Let me repeat it for you, sir. So you have been an arbitrator since 2014,
mm,
and you have a years of experience handling the matter as an arbitrator. So you
mm,
must have gone through, or you must have experienced some loopholes in the legislations of the arbitration. So
mm,
what exactly, can you mention those loopholes that you have experienced?
mm. There are certain loopholes, and the government is making amendments in the act itself to cover those loopholes or to remove the defects or remove the loopholes. Suppose prior to 2015,
Hmm.
there was no time limit for the disposal of the arbitration dispute. Arbitrator was giving date just like CPC, just like civil court. He used to act as a civil court, giving date after date. That is why the amendment was made in the statute and time limit was fixed for the disposal of the award, disposal of the dispute. One year time was fixed. Otherwise, the mandate of the tribunal will be terminated, will stand terminated. This was the loopholes government has by making amendment. this shortcoming has been removed. But still, there are certain shortcomings in the act itself. That parties, there is we can't, whatever the Supreme Court has stated, we have no right to say anything. Whatever the law is there, we have to follow it as it is. We have no authority to question the law passed by the Supreme Court. Sometimes in small disputes, if the other party wants to delay the matter, he will never give consent regarding appointment of the arbitrator. He will
Okay.
never give consent.
Okay.
Then party will have to go to the High Court for the appointment of the arbitrator, because unilateral appointment is
Hmm.
bad in law as per the law laid down by the Supreme Court.
Right.
Earlier, if there used to be a clause in the agreement
Hmm.
that in case of any dispute, party A will will have power to appoint the arbitrator. Now that power has been taken away by the law laid down by the Supreme Court.
Okay.
Now only person, or now if both the parties are agreeing upon the appointment of a person as a arbitrator, only then that person can be appointed as
Hmm.
arbitrator. Similarly, the execution process, now this by way of amendment of section 36(3), the execution process has appears to have become more difficult.
Yes, it does. Yes.
Gives power to the court to stay the
Yeah.
to to grant stay.
The fundamental of this act, on the basis of which this act was made, implemented, was speedy disposal of the disputes.
Yes,
I think that
speedy.
has been breached now due to this
That has been
amendment.
reached now.
Yes.
I think yes.
Yes.
And
So, can you explain the procedure after the matter or any dispute is presented before you under arbitration? What is it like, any different from what it goes when the matter is presented before a judge in a court? Yes, you have experienced both. So, can you explain that?
mhm. In civil courts, you know that civil courts are overburdened. Lot of cases are there. Even one legislation of 138 has increased the number of cases in the courts. Domestic
Okay.
Violence Act has increased the number of
Hmm.
cases in the courts. That is why I am telling you about the courts in Gurgaon. 6 months date is being given because their board is already full. He is a human being. So much number of cases are there. But arbitrator has to, while entering upon reference, has to give an undertaking or have to make disclosure that I am having ability to decide the dispute within the period stipulated by the statute. Time limit has been fixed in the act itself to complete the proceedings, to complete the pleadings.
Hmm.
6 months time has been fixed in the statute itself, that arbitrator has to complete, the parties have to complete their pleadings within 6 months, and arbitrator has to decide the dispute within 1 year.
Hmm.
Can you think that in a civil court, one person will be able to get the matter decided within 1 year after the date of filing the suit? Even 1 year, parties are not served. Sometimes it takes 2 years to get the parties served. But in
Hmm.
arbitrations, because number of parties are few and both the parties have given consent for the appointment of the arbitrator, so generally the parties put in appearance before the arbitrator on
Hmm.
the first notice itself.
Okay.
That is why people prefer to go for arbitration. And in uh, most of the disputes, the another point is court fees. Suppose there is a dispute between the parties and one has to claim 5 crore, 10 crore rupees from the other party and he goes to the civil court, then he will have to affix the court fees first and
Achha.
then the matter will be filed.
Yeah.
In the arbitration, only After passing the award, the court fix is to be affixed on the award itself. For the endorsement of the award, stamp duty is required to be filed. And that is very few. In Delhi, it is 0.1%.
Hmm.
That
So just because you have raised this point of the burden of the court,
is.
judges are less and cases are so many.
Mm.
So why is it so? Why the government is not working on it? Why the appointment of judges are not increasing? Why they don't increase the vacancy in the judicial exams?
That is for the government. Honorable High Courts and Supreme Courts have been insisting upon the governments, have been from administrative side to appoint more judges. But government is having its own limitations
What kind of
regarding
limitations do they have?
main main difficulties of funds. Lot of funds is required to create one additional post of judge. Lot of funds is required. Infrastructure is required. The government is having its own limitations.
Yes.
That is, and one point which I would like to state here that if young advocates are appointed as arbitrators, young advocates, they are having more energy, they are having more capacity to do work as compared to the retired judicial officers or other senior citizens. So they can decide the matter more speedily and more effectively as compared to the senior citizens, retired officers.
Yeah,
Even,
recently this
even,
development
even,
has been made.
even our present Chief Justice also pointed at one
Yes.
time, I do not remember the case, that young advocates should be appointed as arbitrators.
Hmm. In fact, recently it was there was a development in this where the Bar Council of India they're allowing foreign lawyers entry in
Mm,
India, so which is
mm.
a big step, I think.
Yes,
Uh,
it is a big step. It
it's a
is a
big
big
step.
step. Big step. They are right.
Yes. Um, so, what is the procedure after the award is passed by the arbitrator? Or when the execution petition of the award is presented before the district court, what role does an arbitrator has, if any, with regard to the matter in which he has passed an award?
Arbitrator becomes functions officio as soon as the award is passed. He
Hmm.
has no role. But in India, and I have seen that if the award is challenged
Hmm.
before the court under section 34, then arbitrator is also made as a party. I
Okay.
do not know, I have failed to understand that why arbitrator is being made as a party.
Hmm.
He has passed the award. He has already disclosed that I have no interest in any of the parties. I have no interest in the subject matter. He passed the award as per his own understanding, and or he passed the award on the basis of the material available on the record. Then why he is being made party?
Hmm.
The petition which is filed under section 34. Even I have brought one judgment of the Madras High Court,
Hmm.
and it has clearly been stated.
Yes.
Let me find it out, and I would like to refer it here. Let me, let me check it here, and it must be that arbitrator has no role and he should not be made as a party. And this is the authority judgment dated 29/9/2021
Hmm.
in OSA
Hmm.
ब्रैकेट में CAD number 83 of 2021.
Hmm.
Gothari Industrial Corporation Limited versus Messrs. Southern Pro Chemical Industries.
Hmm.
And what the High Court has stated, the High Court of Madras imposed cost of rupees 1 lakh on the appellants for
Hmm.
unnecessarily impleading the arbitrator as a party under Section 34 petition.
Hmm.
The court observed that it is absolutely pointless to make the arbitrator as a party to a challenge petition unless specific personal allegations
Hmm.
are made which would merit an answer from the arbitrator. This is it. So
Yes.
arbitrators should not be appointed as a party. But even I have been receiving summons from the honorable
Court.
court.
Yeah.
If my award is challenged, that I am also included as a party in that petition under Section 34. So I would
Okay.
like to say that it, arbitrator has no role and he should not be included as a party in the
Hmm.
petition.
So now let's talk about the recent judgment of 2021.
Hmm,
In this judgment, in 2021 amendment,
hmm,
we have two primary changes in the act. The first is by adding a proviso under section 36 to
36 3.
3 to enable automatic stay on awards
Hmm,
in certain cases where the court has prima facie evidence that the contract on which award is based was affected by fraud and corruption.
hmm,
And the second change is the eighth schedule's omission from the Principal Act. This particular schedule talks about the qualification of an arbitrator. So, and regulations, experience of an arbitrator, norms for accreditation of arbitrator, everything. So, this schedule in itself has been omitted. So, what is your view on the unconditional stay under Section 36(3) of the Act?
hmm. No amendment has been made, and the duty of the court is to interpret the law as it is.
Hmm.
The legislatures, the parliamentarians who have framed the law, they must have been in their mind and they framed the law as per the changed scenario. They must have felt that contracts, fraud, and corruptions are affected while executing the contract or while obtaining the award. That is why they have inserted this clause in the Arbitration Act itself, and rightly so. Here I say rightly so, because in most of the cases, fraud or corruption is exercised by taking the illiteracy or simpleton advantage of the simpleton of the other party, mostly in uh, in collaboration agreements. Sometimes real estates are executing collaboration agreements with the agriculturist. Sometimes such clauses are inserted
Hmm.
without explaining to the farmers or simpleton persons that which is the result of fraud or corruption. Then court has power to prima facie. The word prima facie has been, if the prima facie court, if the court is of opinion that it has been affected by exercising fraud or corruption, then court has power to stay the
So, but
unconditional.
this court has nowhere have legislatures have not mentioned the grounds. They have not explained what could be fraud and
Fraud
corruption.
has been defined in contract act itself. If a particular clause has not been defined in the act itself,
Hmm.
then we can take the help of other statute. This is the basic law. If the fraud
Yeah.
has not yet been defined in the arbitration act itself, then it has been defined in the contract act.
But sir,
You
what
get
about the parties against whom the word has been passed? They will make exploit this section by again going to the
Yes,
court and
this is the this
right.
is the this is the this is the your apprehension is correct. The party who wants to delay the proceedings and
Hmm.
whose only intention is to delay the matter, or who does
Hmm.
not want to get it decided at earliest, then
Yes.
they may take that misuse this provision.
Yeah. And
Can
speedy
delay the
justice is
proceedings.
against breached, which was the
Justice is
crux of this.
that
Yeah.
is that this is the yes.
And so
But
many
but
parliamentarians also criticize.
court has to
Hmm.
court has to apply his mind.
Hmm.
And if the court prima facie finds, actually, judicial officer has to apply his mind. And sometimes after going through the file, after going through the conduct of the parties, after going through the uh, other documents,
Hmm.
the court may arrive at the conclusion whether it is a prima facie, it is a case of fraud or not. The court can arrive at the conclusion.
Yeah.
Court has discretionary power in
Hmm.
granting
Hmm.
stay is being granted by the courts. The court
Hmm.
has to see prima facie whether right is existed, whether it has been infringed, whether prima facie case is made out or not, whether irreparable loss is going to be called to the other party or not. Court has to apply its mind. The court, after going through the documents, if comes to the conclusion that there is a possibility of exercise of fraud or corruption, then court can grant unconditional stay.
And so what about the second amendment, which is
Second
the
Amendment, I think that is the
Hmm.
object of the Second Amendment is to
Yes.
boost the international, to make the India a hub of international arbitration.
Yes.
Other international people will also come here for
Hmm.
arbitration, for initiating arbitration proceedings.
Right. I
I
think
think
it's
eighth
yeah, the
schedule has
doors have
been
opened.
deleted. Eighth schedule, I think, has been deleted by way of amendment of 1921.
2021, yes.
Yeah, yes, 20.
Yes. So at last, I would ask you that what do you think should legislatures do to overcome all the issues that we have discussed today?
Definitely, definitely. Legislatures keep in mind what are the shortcomings, how they can improve how the object of the statute can be achieved by making amendments.
Hmm.
Exactly. The act has been enacted with a purpose to give speedy and cheap justice to the parties in commercial dispute. For achieving this object, if the legislature thinks that certain amendments are required to be made, then they can make amendments from time to time as per the need of the hour.
Yes, but
That's
the
all.
amendment, the last amendment was made in 2015,
Mm,
then 2019. Then
mm.
2019, then right after 2019, after 2 years, another amendment was introduced.
There were certain ambiguities in it was not very much. The 2015, uh, there was no, it was not clear that from which date the period of 1 year will start for completing the arbitration proceedings. Then, by way of making amendments, it has been clarified that period of 1 year will start from the date of completion of the pleadings.
Okay.
There were certain shortcomings. So, if the legislation is discussed properly or sufficient time is given in the parliament before enactment, then there will be less requirement for making amendments. So it may be reason that legislature is not properly discussed in the parliament before enactment. That is why there is a need for making amendments one after another.
Yes. So it was great listening to you. And I would conclude this today by saying that the amendment to Section 43J also has the potential to draw international arbitrators, which is a
Yes,
small step towards the pro arbitration scheme of India. And
yes,
further, the ambiguities that we have discussed that are exploited by the losing party, which is under Section 36(3),
mm,
and when they go to the party for challenge the award, which has led to lack of finality of awards and also frustrated the mere fundamental of arbitration act, which was speedy justice. Also, I think arbitral tribunals should also be permitted to use different ADR mechanism during the arbitral proceedings to encourage settlement of disputes as may prove to be more effective.
very right.
Yes, sir. Thank you so much, sir, for giving us your insightful knowledge on arbitration. It was really amazing to hear you on this topic.
Thank
And
you.
with this, I end this webinar. And to our viewers, I would say thank you for your support and please keep watching us.